Indianapolis, February 5, 1992. Wednesday afternoon, 2:17 p.m. The courtroom is packed, every seat filled, journalists shoulder to shoulder in the press section, cameras outside because Indiana doesn't allow them inside during testimony, everyone waiting for what comes next. The prosecution has spent 9 days building their case against Mike Tyson. 26 witnesses, medical evidence, expert testimony. The story of what happened in room 606 of the Canterbury Hotel on July 19, 1991. Desiree Washington's account of being raped by the most famous boxer in the world. The defense has responded predictably, attacked her credibility, suggested she wanted money, suggested she knew what she was getting into, suggested the sex was consensual. Their strategy is clear. Make the jury doubt her, make them think she's lying, make them believe Mike Tyson, heavyweight champion, cultural icon, is the real victim here. The defense has just rested their case. Presented 14 witnesses. Character witnesses for Tyson. Medical experts who disputed the prosecution's interpretation. People who saw Desiree Washington before and after and said she seemed fine. Their closing argument is scheduled for tomorrow. Then the prosecution gets their rebuttal. Then the jury deliberates. Standard trial procedure. Everyone expects it to follow that timeline. Then something unexpected happens. Judge Patricia Gifford asks if either side has any additional matters before they break for the day. The defense says no. Gregory Garrison, the lead prosecutor, stands up. Says he has one more witness. The courtroom stirs. One more witness. Who? The defense attorneys look confused. Check their notes. They've seen the prosecution's witness list. 26 names. All of them have testified already. Who's left? Judge Gifford asks Garrison to identify his witness. Garrison says calmly, clearly, with absolute confidence, "The state calls Gregory Garrison." The courtroom explodes. Not literally. But the energy shifts instantly. Reporters lean forward. The defense team starts objecting immediately. Judge Gifford bangs her gavel, calls for order. This is unprecedented. The lead prosecutor taking the stand as a witness in his own case. It almost never happens. The ethical complications are enormous. The strategic risk is massive. If Garrison testifies, he opens himself up to cross-examination by the defense. They can attack his credibility, question his motives, try to make him look biased or dishonest. Everything he says will be scrutinized not just as legal argument, but as sworn testimony. One mistake, one inconsistency, one moment of weakness, and the entire case could collapse. The defense is on their feet. Vincent Fuller, Tyson's lead attorney, one of the most respected defense lawyers in America, argues vigorously against allowing this, says it's improper, says it's prejudicial, says it violates every norm of criminal procedure, says Garrison is trying to grandstand. Judge Gifford listens. She's been a judge for 16 years. She knows the law. She knows the risks. She also knows that prosecutors are allowed to testify in their own cases if they have relevant evidence. It's rare, but it's legal. After 5 minutes of arguments from both sides, Judge Gifford makes her ruling. She'll allow it. Garrison can testify, but she warns him, warns that everything he says will be subject to cross-examination, warns that he's putting himself and his case at enormous risk, warns that this better be worth it. Garrison nods, says he understands, says it's necessary. The bailiff swears him in. Garrison walks to the witness stand, sits down, looks at the jury, 12 people who will decide if Mike Tyson goes to prison. 6 men, 6 women, mixture of races, ages, backgrounds. They've been listening to testimony for 2 weeks. They're tired. They've heard everything. Medical evidence about Desiree Washington's injuries, testimony about her emotional state after the assault, Tyson's driver describing how Desiree looked when she left the hotel, character witnesses on both sides, expert testimony about rape trauma syndrome, hours and hours of technical legal proceedings. Now the lead prosecutor is testifying. Why? One of Garrison's junior prosecutors, Barbara Trathen, stands to question him. This is also unusual. Normally you don't question your own boss on the stand, but they've planned this carefully. Trathan asks Garrison to state his name and position. He does. Lead prosecutor for Marion County, Indiana. 23 years as a prosecutor. Hundreds of cases. Dozens of rape cases specifically. Trathan asks why he's testifying. Garrison takes a breath. Then he tells a story the jury hasn't heard yet. A story about what happened 3 days after Desiree Washington reported the rape. About a conversation that changes everything. Garrison explains that on July 22, 1991, 3 days after the assault, he received a phone call. Not unusual. Prosecutors get calls constantly. Tips, questions, complaints. This call was different. The caller identified himself as someone from Mike Tyson's camp. Not Tyson himself. Someone who worked for him. The caller said they wanted to resolve this situation, wanted to make it go away, asked what it would take. Garrison says he knew immediately what this meant. This was an attempt to pay off Desiree Washington, to buy her silence, to make the case disappear before it became public, before it destroyed Tyson's career and reputation. The caller suggested money, a significant amount, enough to change a college student's life, enough to make this whole thing go away quietly. No trial, no publicity, no damaged reputations, just money changing hands and everyone moving on. Garrison says he told the caller this wasn't how things worked, that you can't buy your way out of a rape charge, that Desiree Washington had rights, that the state had an obligation to prosecute crimes regardless of the defendant's wealth or fame. The caller persisted, said everyone has a price, said they could make Desiree very comfortable, said she'd never have to work, said this could benefit everyone. Garrison says he ended the call, told them any further contact of this nature would be considered witness tampering, that if they contacted Desiree Washington or her family with offers of money, he'd file additional charges. The courtroom is silent. The jury is locked in. This is new information, information that reframes everything. The defense team is scrambling, taking notes frantically, preparing their cross-examination. They know this is devastating. Trathan asks if Garrison documented this call. He says yes, wrote a memo immediately afterward, filed it with the case materials. The defense had access to it during discovery but chose not to address it. Trathan asks what this call meant to him as a prosecutor. Garrison looks directly at the jury, says it told him everything he needed to know about this case. That guilty people try to make cases go away. Innocent people fight to clear their names. They don't offer money to make accusations disappear. They demand their day in court to prove they did nothing wrong. Tyson's people tried to buy silence. That's consciousness of guilt. That's an admission that something happened in that hotel room that Tyson didn't want examined in public. Trathan asks if there were other attempts to influence the case. Garrison says yes. Multiple calls over the following weeks. Different people. Same message. How much money to make this go away. He documented each one, reported them to Judge Gifford. The attempts stopped once the trial date was set and the case became too public to quietly resolve. Trathan has no further questions. Now comes the dangerous part. Cross-examination. Vincent Fuller approaches the witness stand. He's been doing this for 30 years. He's made careers out of destroying witnesses on cross-examination. He's defended some of the most powerful people in America. He knows exactly how to attack Garrison. Fuller starts calmly, asks if Garrison has any direct evidence that Mike Tyson personally authorized these calls. Garrison admits he doesn't. The callers never claimed to be speaking on Tyson's direct orders. Fuller pounces, says so this could have been overzealous representatives acting without Tyson's knowledge. Garrison says that's possible but unlikely. Fuller asks if Garrison recorded these conversations. Garrison says no. Fuller asks if he has witnesses to these conversations. Garrison says no, they were phone calls to his direct line. Fuller suggests that without recordings, without witnesses, without direct connection to Tyson, these alleged calls are just Garrison's word. Convenient testimony from a prosecutor who needs to win this case. Garrison stays calm, says his memos were written contemporaneously, says his credibility as a prosecutor with 23 years of service speaks for itself, says the jury can decide whether to believe him. Fuller shifts tactics, asks if Garrison is aware that offering to settle civil matters is completely legal. that suggesting financial compensation to avoid litigation isn't a crime. Garrison says this isn't a civil matter. This is a criminal case. You can't settle criminal rape charges with money. That's not how the system works. Fuller asks if Garrison has ever seen cases where victims accept restitution as part of plea agreements. Garrison says yes, but that's different. That's through official channels with judicial oversight. That's not secret phone calls trying to buy silence before charges are even filed. Fuller asks if Garrison's decision to testify today is motivated by the fact that his case is weaker than he expected, that Desiree Washington's credibility has been challenged effectively, that the medical evidence is ambiguous, that Garrison needs to do something dramatic to save a failing prosecution. Garrison says firmly that his case is strong. The evidence is clear. The testimony is consistent. He's testifying because this information is relevant and the jury deserves to know it. Fuller asks if Garrison is aware that taking the stand as a witness in his own case is seen by many legal experts as a sign of desperation. Garrison says he's aware some people might see it that way, says he doesn't care, says doing the right thing sometimes means taking risks. Fuller has been going for 20 minutes. He's tried every angle, tried to discredit the phone calls, tried to separate them from Tyson, tried to make Garrison look desperate or dishonest. Nothing has landed effectively. Garrison has stayed calm, consistent, credible. Fuller knows when to stop. He ends his cross-examination. Garrison steps down from the witness stand, returns to the prosecution table. The entire testimony took 1 hour and 8 minutes. 1 hour that changed everything. The jury has new information now. Information that connects directly to their core question. Did Mike Tyson rape Desiree Washington? They can't unhear what Garrison just told them. That people connected to Tyson tried to make this case disappear with money. Tried multiple times. Stopped only when it became impossible. That night, the legal analysts on television are divided. Some say Garrison took an enormous risk that could backfire. That putting yourself on the stand as the prosecutor is almost never a good idea. That if the jury doesn't believe him, the entire case collapses. Others say it was brilliant, that Garrison recognized his case needed one more piece, one more element to push the jury from reasonable doubt to certainty, that the attempted payoffs show consciousness of guilt more clearly than any other evidence could. The next day, closing arguments begin. Fuller argues for 3 hours, says the evidence doesn't prove rape, says Desiree Washington is lying, says she saw an opportunity to get money and fame from Mike Tyson, and she took it, says the phone calls Garrison testified about, if they even happened, prove nothing, says Tyson is innocent. The prosecution's closing argument is shorter, more focused. Garrison walks the jury through the evidence methodically. The medical evidence showing trauma, the testimony showing Desiree's immediate distress, the pattern of behavior consistent with assault. Then he addresses the phone calls. Says, you've heard about attempts to make this case go away with money. Says innocent men don't do that. Innocent men don't hide. They don't pay for silence. They fight. Says Mike Tyson's people knew what happened in that hotel room, knew it was rape, knew if it went to trial the evidence would be damning. So they tried to buy their way out. Says that attempt failed because Desiree Washington refused to be silenced, refused to take money instead of justice, chose the harder path because it was the right path. Says the jury should honor that courage by finding Mike Tyson guilty. The jury deliberates for 9 hours. On February 10, 1992, they return with their verdict. Guilty on all counts. Rape. 2 counts of criminal deviant conduct. Mike Tyson shows no emotion. His legal team immediately announces an appeal. But the verdict stands. 3 months later, Tyson is sentenced to 6 years in prison. Serves 3 years. His career interrupted at its peak. His reputation permanently damaged. Gregory Garrison's decision to testify becomes a case study in law schools, an example of a prosecutor taking an extraordinary risk that paid off. Some professors use it to teach about courtroom strategy. Others use it to teach about ethics, about when it's appropriate for a prosecutor to become a witness, about the dangers and rewards of unconventional tactics. Garrison himself rarely discusses it publicly, says he was doing his job, says the evidence demanded it, says if he hadn't testified, the jury wouldn't have known about the attempted payoffs. says that information was too important to keep out of the trial. In later interviews, some jurors say Garrison's testimony was significant in their decision. Not the only factor, but important. It corroborated their instinct that something was wrong with the defense's version of events, that innocent people don't act the way Tyson's representatives acted, that the pattern of behavior suggested guilt. One juror says the medical evidence convinced them something violent happened. Desiree Washington's testimony convinced them it wasn't consensual. Garrison's testimony convinced them that Tyson knew it was rape and tried to cover it up. All three pieces together made the verdict inevitable. That's what 1 hour of testimony accomplished, 1 hour that turned history. Not by introducing dramatic new evidence, not by catching anyone in a lie, but by connecting dots, by showing a pattern, by demonstrating that the defense's narrative that this was consensual sex being reframed as rape for money made no sense when Tyson's own people were offering money to make it go away. Gregory Garrison took a risk that day, put his credibility on the line, subjected himself to cross-examination by one of the best defense attorneys in the country, did something that prosecutors almost never do. He did it because he believed in the case, believed in Desiree Washington, believed the jury deserved every relevant piece of information. That 1 hour of testimony, coming at the end of 2 weeks of trial, crystallized everything, made clear what this case was really about. Not celebrity versus nobody, not reasonable doubt versus absolute certainty, but truth versus power, justice versus money, a young woman's courage versus a system designed to protect the famous and wealthy. For 1 hour, Gregory Garrison made sure the truth won.